Hello friends, welcome. Friends, just on 6th of April 2025, I wrote an article and I did a video. In this article, I had given options that what options the government of India has to bail out Vodafone from their AGR obligation, which is going to be very huge, which is going to be 18,000 crores of rupees before 31st March 2026. And if they don't pay this, then they are going to be a huge problem. So there are three options before the government to deal with this issue, and you can read this article and I will paste a link in the description of the video I had done. Now friends, why I am doing this video again today? In this video, I want to tell the viewers as to why it is morally important for DoT to act and bail Vodafone out. Reason? Every party, including DoT, TRAI, courts and the operators all were responsible for this mess together. And there is a large amount of responsibility lies with DoT, and DoT cannot exclude its responsibility by saying that the court's order have been given, because they were initially, when the whole issue started, they have been changing their stands on a continuous basis. And some of the stands which DoT has taken has been extremely unreasonable. So this is the reason I'm doing this video. So what I'm planning to do is I'm going to do this video in two parts. The part one is facts and the part two is mistakes, right? So both are important to be judged or done separately, because if I do mistakes and facts together, it is going to create confusion. So facts have to be dealt with in isolation, then only we will be able to understand what the mistakes which have been committed and why DoT should act and resolve this issue. Okay, so let's start without wasting any further time. And in this video, we are going to go and look into official documents. It is not going to be a speculation, friends. Okay. So I did this article long back, just after the Supreme Court judgment, which was on 10th October 2019, which was a watershed judgment. So let's look at what the facts are. The fact number one is operators had unconditionally accepted the DoT's migration package. Friends, you know that the fixed license regime was migrated to revenue share at the behest of the operators who were in the face of bankruptcy. So they requested DoT, please give us, bail ourselves out, and there was an agreement, there was a settlement, and DoT came out with this migration package. And this migration package was unconditionally accepted by the operators. But there is one important thing which we need to understand and take note of, that definition of revenue was to be decided by DoT and the operators through a consultation process, a transparent consultation process anchored by TRAI. So how do I know that? So if you go here onto the migration package, this is the date of the migration package. It kind of gives us the definition of revenue, and it says that the definition of revenue it does not give the definition of revenue. It says that the definition of revenue for the purpose shall be decided later, and it will be on the receipt of TRAI recommendation. So this is fact number one. The fact number two is DoT sought recommendation of TRAI but rejected it without any reason. Now, if suppose you ask for recommendation and it is done through a open consultation, if DoT had to reject TRAI recommendation, they were well within their power. But rejecting it without any reason was a unilateral stance, which kind of shows that they really didn't care what the industry has done, what TRAI has done, the whole process which got executed, right? On the behest of the understanding at the time of the migration package which was signed, was completely disregarded by DoT, which is not a responsible behavior. Now, why do I say this? Let's look at the document. And this document is the reference. This is the back reference of DoT, which is as per the TRAI Act. DoT has to send any kind of disagreement to TRAI. So they did so. The revenue share definition, DoT is saying that the government has proposed to follow a definition of adjusted gross revenue for the purpose of computing license fee, which is different from the definition recommended by TRAI. Now, this was not enough. This was supposed to be, anchored with or supported with reasons. What the DoT did not give any reason, and TRAI goes on to say that we have been recommending the definition of license consistently, and which includes that the revenue should be accrued on operator from license activities and excludes all items unrelated, which are non-license. Okay, so this is fact number 2. Fact number 3 is DoT carried out an independent analysis on the definition of revenue by hiring a consultant on 6th of October 1999. Now, mind you, this date is important, 6th of October, because the migration package was signed on 22nd July to 1999. Just after the migration package, DoT started carrying out its own independent analysis because they were concerned that the definition of revenue on which the license fee was charged should not be a loosely defined item. It should be robust enough so that the government does not lose any leverage or any revenue. So they hired an independent consultant. Now, there is nothing wrong with that. But what went wrong is that the hiring of consultant and the analysis which DoT was doing on a parallel basis along with the TRAI consultation process did not converge. It should have been converged, means that when an entity, a licensor and a licensee and the industry stakeholder all part of the same deliberation, which is the definition of revenue, which was supposed to be decided by through a TRAI consultation, any input DoT gathered on by independently should have been part of the TRAI consultation process. It did not. So it was carried out independently, and that is the reason why DoT made a statement here, in the back reference, that the government proposes to follow a definition of AGR which is different from the definition issued by TRAI. So fact number 4 is DoT did not place the report of the consultant before TRAI while seeking recommendation. Fact number 5 is operators' initial grievance before the Supreme Court and all the adjudicating agencies were centered around DoT's claim from license fee from non-telecom revenues, which does not require a license from DoT. So this was the central argument. Fact number 6 is before the OSPI case, which is the 2011 Supreme Court judgment, all TRAI recommendation and TDSAT judgment were principally anchored upon the assumption that DoT has no right of seeking license fee from non-telecom revenues. This is fact number 6. Fact number 7 is the Supreme Court judgment of OSPI case, which is on 2011, implicitly established DoT's right to as an issue which could not have been challenged at TDSAT, and I'll tell you the reason why, of seeking license fee from non-telecom revenues emanating from operators' entity to hold the license. Now, what happened was that there were multiple litigation which we are going to discuss. The matter went to Supreme Court, and when Supreme Court looked at the case, they figured out that when a contract is being entered into by DoT and the operators, TDSAT cannot decide the terms of the contract because the contract is between DoT and the licensees. TDSAT is an entity which can only interpret the contract. It cannot say that what should be part of the license, what should not be part of the license. And that is what the Supreme Court said in its judgment in 2011. And therefore, it says that TDSAT judgment actually has no jurisdiction, and therefore DoT has full right to collect whatever revenue that they want to collect. And in the second part of the video, I am going to tell you that what was the mistake in this OSPI judgment. We are not going to discuss in this part of the video, and why this judgment was incomplete. We are going to talk about that. Fact number 8, in the OSPI case, Supreme Court did not go through the specific of DoT's demand. Why? Supreme Court said that, look, you guys do not have any jurisdiction, TDSAT, but you can interpret the contract clause by clause. So, if any of the demand of DoT is not as per the contract which DoT has signed with the licensee, those items can be individually seen by the TDSAT and interpreted whether it is as per the contract or not. So, you do so if any of the demands of DoT is not as per the contract, in which you didn't have any jurisdiction to decide first, you can go into that. And that is what the OSPI case said. TDSAT should go into the legality of this demand, which is in the purview of the license agreement, not the terms of the license agreement, which was the right of DoT to decide between the operators and the DoT, where TDSAT had no jurisdiction. Fact number 9 is that both TDSAT judgment of April 2024 and the current judgment, which is the 10th October 2019 judgment, after which I wrote this article, is based on DoT's right of collecting license fee on non-telecom revenue. This is fact number 9. Now, reason for dispute. Let's look at reason for dispute. It is clear from the fact that DoT had set an expectation on the operators at the time of signing the migration package that the definition of revenue will be decided after a proper consultation with TRAI. It was very, very clearly established. I showed you the document. So it was clearly established. Hence, it seems that the operator assumed that it is okay to sign the migration package unconditionally, as they will also have some say through the TRAI consultation process on contributing to the definition of revenue. So operator thought that they will contribute, they will have an agreement, everybody will be fair. They never thought that DoT will unilaterally decide the definition of license fee without putting the consultant report before the TRAI consultation process. So this was completely a setback to the operator, because DoT said that nothing doing, I have the power, I will decide. I don't care about the TRAI consultation process. Okay. So that is the problem that basically happened. Now, by the way, they had no option, but they didn't get to contribute, right? As a migration package was offered as a bailout, so there was no contribution. So it's like a unilateral contract, right? Because you were in the stage of bankruptcy. You were giving a bailout. You signed that bailout unconditionally. Because if you didn't, you are going to die. Now, in a country where everybody is seen as a stakeholders, nobody, no institution, whether it is judiciary, whether it is the government or the regulator or even the stakeholders, the operators themselves, to behave as if that they are completely insensitive to the overall system, to contribute and let the system grow together. You can't simply say that I don't even care whether you are alive or whether you are dead, because if you are alive or you are dead, the whole institutions, the whole system and the consumers are getting affected, right? So you can't really act as a passive manner. This is one of the mistakes we are going to discuss when we discuss the mistake. Because of this, DoT's inability to share the consultant report and rationale, TDSAT on 7th July 2006 ordered TRAI to provide its recommendation after going through the DoT consultation. So TDSAT said that, look, I do understand that I can't decide the terms of the contract, plus please DoT bring your consultant report and put it before TRAI and let's have an open consultation in a fair way. So let's discuss each and every item. And then TRAI did it on 13th of September 2006. But this act of TDSAT was declared illegal by Supreme Court on 11th of November 2011 on the OSPI case. Now you understand? So all that happened, TDSAT did whatever that was supposed to be done, but later in the 2011, OSPI said, Mr. TDSAT, you really didn't have a jurisdiction. So why are you wasting your time? It's almost like that, right? As according to SC, TDSAT had no power to order TRAI to make recommendation on issues that came before DoT issued a license to the operator. According to SC, TDSAT has power only to adjudicate matters between a licensee and a licensor, not before. This is the foundation of OSPI case. Hence, though DoT was legally correct in rejecting TRAI recommendation, but was morally wrong not enabling a proper consultation, and also not explaining that why it rejected TRAI recommendation of keeping non-telecom revenue out of the purpose of license fees. Right? You got it? Right? It flows logically, by the way. Lengthy battle. SC's judgment of 2011 and now, which is 2019, 10th October 2019, it is mentioned that it is wrong for the operators to have contested the definition of revenue after having accepted the migration package unconditionally. Why? Though the argument stands legal scrutiny, but it is untenable given the fact that neither parties, DoT and operator, understood the definition of revenue when they decided into the contract. So there are two issues here. What basically said that you have accepted unconditionally. But the fact is that no party, neither the operator nor the DoT, had any clarity on the definition of revenue, because everybody was doing its own analysis. And I'll show you by pointing document that DoT was unclear on the definition of revenue even when the 2011 Supreme Court judgment came. They were giving lot of concession to the operator on the definition of revenue, right? Before hardening their stance after the 2011 case. And even though after the 2000 case, DoT gave some concession to the operators, when the final judgment of 2019 came by the Supreme Court became so harsh, they told DoT that you have no power to give those concessions. So first, DoT didn't understand. Second, DoT gave some concession. Those concessions were, were diluted. And when the final judgment of Supreme Court 19 came, DoT still had certain concession given to the operator. Supreme Court in the final judgment said that these concessions were not even allowed by you. You have no capability to give those concessions, right? You understand the sequence of what happened? So DoT's rationale was based on the consultant report, that in case the non-telecom revenues are kept out of the gross revenue, then what will happen? Then the operator will be motivated to do accounting jugglery and escape the license fee. But the primary rationale for including non-telecom revenues under the fold of revenues, this was the primary rationale. But in no case, at least in the initial battle, DoT had thought this through. That is the logic of stretching this rationale further. This is evident from pursuing the DoT's TDSAT judgment. Now let's look at this judgment. It is very, very crucial. So I'll just go to the judgment, which is of what is the date? 30th August 2007. So let's look at the 30th August 2007. This is the judgment. Now here you will see that there are many items where DoT was confused completely. Like for example, capital gain. DoT said that you are going to basically include capital gain within the AGR, right? Within the revenue, but it did not explain its stand, right? Without giving any stand, it went on. Then gains from foreign exchange fluctuation, right? What TDSAT is saying that, secondly, the union does not say anything whether they will permit deduction from AGR if the losses are happen on account of fluctuation. Then reversal on vendor credit. So Union of India has got nothing to cover this, right? There were certain things which were discussed here. You can pause the video, have a look at it. Income from property rent. DoT accepted TRAI recommendation on this, right? And then there are other items too, right? Other income included in the miscellaneous report. There was certain observation made, and DoT agreed to the recommendation of TRAI to exclude certain items, right? So this is what the TDSAT judgment said. So which basically said that DoT had given a lot of concession, which I was mentioning, and they had a stand which was reasonable. It was not a very unreasonable stand till the Supreme Court judgment. So let's look at the TDSAT observation. Now, once the TDSAT jurisdiction was cancelled by the Supreme Court, or kind of, they had legally said that TDSAT doesn't have the jurisdiction, TDSAT became very, very frustrated. So let's look at the TDSAT observation, right, which we can see in the 23rd April 2015 TDSAT judgment. So let's look at this judgment. Now here you will see what TDSAT is saying. It's saying, in the hindsight, it would thus appear that in the first round of litigation, the licensee themselves are inviting the judgment of the Supreme Court, greatly extending the parameter of the relevant clauses in the license agreement by raising dispute to almost an abstract level instead of disputing on facts. The inclusion of certain items such as inflow as gross revenue as insisted by DoT. So they're saying that, look, you have invited this problem upon you because you went much ahead and argued the case on an abstract level. That's why you are in this situation, right? Now, let's look at certain things which are important, right? So here you see the current SC judgment. It appears to me that the current SC judgment is quite harsh. Current means 2019 judgment when I'm writing this article. It expanded the definition, right, of revenue further by including items which normally falls under the category of income like capital receipt, etc., right? And there were certain contradictions also. And in that judgment, if you look at it in the judgment, DoT really gave some concessions. So I'll just point to the TDSAT judgment first, And in that judgment, if you see, when TDSAT said that the operators have invited this problem upon themselves, where it is, which I just showed you. This one. So here, if you see here TDSAT is quoting a Supreme Court order of 11th of August 2011, and it says that during the course of the hearings, Mr. Soli Sorabji, which is our DoT's Attorney General, learned senior counsel placed on record the following stands of DoT. Right? It says that. And what is this? This is the TDSAT judgment of 23rd April 2015, when it got frustrated. It said, department stand is that the revenue from non-telecom business, which is entirely different from the telecom business of the license, is not included in the definition of GR. So it is Solirajji saying there, right? This is also the consequence of maintaining separate accounts. You can see that what DoT had in their initial stages of submission by different lawyers. And then it says, at no stage of development, it seeks to levy revenue share in respect of various licenses held by the company on revenue received from more than once. All discount mentioned in the price list before the TRAI are excluded. So this is what the DoT's counsel said, and TDSAT had recorded this in the 2015 judgment, right? So the current SC judgment, which we are going to discuss at a time when we talk about mistakes in more detail, so I will not like to basically repeat it. So I am going to just leave this for the next part of the video. We'll also exclude the implication. Now, why is the reason for this outcome? The reason for this outcome is clear. Both parties dragged this issue too far, to an extent that DoT got an opportunity to harden its stance to a level of unreasonableness, right? The high courts came in, but there was no decision yet from them at that particular point of time. The case exposes the vulnerability of our legal system. Operators should have visualized this risk much earlier and advocated a AGR-free regime before the 2010 auctions. They do not want free spectrum anymore. That is, they do not want free spectrum anymore and are willing to acquire it through auction and return for an AGR-free regime. They did not do that because they were getting free spectrum, right? Doing so would have prevented the 2G scam. In my earlier note, I talk about the untold story of 2G scam. Unfortunately, better sense did not prevail, as seeking an earlier compromise could have created a much needed certainty and prevented this outcome, where there is a burden of not only the interest and penalties, but also the losses to business flexibility. Now, conclusion, before I get to the next part of the video, the key rationale used in educating agency, especially SC, is that the operator having benefited from the migration package. This is the key rationale, right? But what they missed in the narrative is that it is not the operator benefited, it is the whole country benefited, means DoT benefited, because without the participation of the operator, without giving the operator the needed benefit, the tele-density of the country would not have increased so much. So that is the way to look at it. It has to be an inclusive way to look at the whole situation. Then it is also clear neither DoT nor the operator had any clear understanding of the definition of revenue at the time when the package was signed, right? So if you have no clarity of definition, how can you say that you sign unconditionally? This was completely unreasonable. You go and talk to any competition agency, right? And you say that if you are in a dominant situation and if you are letting somebody to sign and contract in a dominant situation when the other party doesn't have a leverage, that contract is not valid. It does not apply to the government, but the government has got responsibility. They are to be acting responsible in the larger interest of the country. They cannot be saying, that in letter you have signed this and therefore you have to follow it. We don't care what happens to the businesses. Let it die because this is what our rights are. This is not the way to look into the situation. Therefore, in national interest, it is important that we handle all the matter with responsibility and to ensure that the operators are continuously motivated to offer world-class telecom services. Now, friends, this is the first part of the video. And the next part, you will understand that why it is extremely important, because this first part of the video tells you that why it is important for DoT to give some kind of bailout, because they were themselves responsible. The next part you can see the lacuna in the judgment. In the Supreme Court judgment, the Supreme Court order, as well as the judgment of 2019 and 2020 and the Telemagic judgment which happened in the TDSAT in the later part of 2022, right? So I'll come back with the video in the next part. I hope that you liked it. And the reason I'm doing this with so much amount of enthusiasm and passion, because we want to get out of this mess. And that's why this story has to be told in a very simple form. This is a lot of hard work, friends, going through all this document and underlying all these documents, right? So, friends, I'm going to paste in some of the documents, the link of this whole thing in the description. And thanks for listening till the end. And I'll come back with the next part of the video as soon as possible before the viewers. Thanks for listening till the end. Thank you very much.